With the initial, excuse me, with the initial move-in inspection, who really should be handwriting the notes? The landlord or the tenant?
You know, I don't have any problem with either one of them. There isn't any rule. The better off, you're better off if the tenant participated in it, right? And you don't want it to come across to the court as this was unilaterally dictated, which is why I made the tenant provide a second one on their own a week after they've had a week to live there. Because then that's their issue. And then, of course, if there's anything that they put on it, follow up on it promptly. But that, I think, secures your position with that. Sir, yes, sir, here's another question.
What if a tenant doesn't do a walkthrough on the way out with you?
That doesn't matter. They're not required to do, you're not required to have them do a walkout. You're required to do one yourself, to do that final inspection, and have it in the mail with any deposit that's due, if due, or any bill that you know of at that point, within 14 days of taking possession. But they don't have to participate. So don't wait on them. I mean, if you get the keys back, or at the point you get possession, from the change of possession, you got 14 days and the clock is ticking. If you don't do that timely, they can demand twice the deposit back, and they will probably get it.
I have one more
Plus
question.
attorney's fees if they have to sue for it. Yes, sir?
One more question regarding, you said security damage deposit. In most cases, those are either tied together or you separate them out and spell them out. What do you recommend?
You know, I don't necessarily think there's any particular better way. As long as you've got some language in there that makes sure that the security can be used for amounts owing, rents owed, utilities, NSF fees, you know, whatever they may have skipped out on. Got that language in there clearly, then I don't have any problem commingling it with a damage deposit. But if you just call it a damage deposit and expect to be able to apply it to rents they skipped out on, you're going to have a problem.
So if it's worded as a security damage deposit, that's
Security damage deposit, but I'd go further and say that security, including but not limited to, rents owed, utilities owed, you know, whatever, NSF fees, whatever else your contract might provide for them paying, I would spell it out. With and we always use included but not limited to. Remember that. Yes, sir?
If you put it in the contract, can you charge for a 3-day or 10-day notice?
Yes. But be careful that you word it in such a way that if you have to issue it, you're entitled to it, okay? A lot of contracts want to read the prevailing parties entitled to those fees. If you don't go to court and finish it up and prevail, then you may not be entitled to that. So be careful that if you're going to give a notice fee, or you know, charge them for having to post a 3-day or 10-day or whatever, that you say that you're entitled to that regardless of whether it goes to court or not, okay?
I have a question.
Have a clause that requires your tenant to promptly report any and all maintenance issues in writing. Have them initial that clause, right? Put the burden on them. Yes, ma'am.
I have a question going back to the 14-day. If you have a property that's severely damaged or has been left, and there's estimates that are outstanding and you can't determine that, is a statement
Give your best estimate,
and send them that
get it out within 14 days, and then if you need to send additional bills later or send them to collections later with some additional costs, you got a good shot at that being
So
included.
you don't actually have to send any funds per se on that 14th day. It could be a statement.
If you've got a good faith estimate that makes you think that you're not going to be giving any funds back, then just do your best to explain why,
Okay.
right? I mean, the further you can get, the faster you can work, the better. Give a good faith estimate, you know. You may not, their wood floors need replaced, you may not know what it's going to cost yet, but estimate it
Right.
and deduct for that. As long as it's relatively detailed, it doesn't have to be precise.